time.
Mm.
Good morning.
Good morning. Good morning. I hope you're well.
I'm doing great yourself.
I am also doing well. First, I want to hear your own views on the decision that has been made by the High Court. Did the High Court get it right?
Okay, so let me wish your lovely listeners a good morning. Now, I think there are two, in my opinion, two issues to be discussed. The first is, first of all, did the High Court judge have the power to make the decision he made? Because essentially, in my opinion, the decision he made was to hold an act of parliament to be unconstitutional, because the OSC is the body created by an act of parliament. And the second issue has to do with the substance of his decision, whether or not under Article 88.3 and 88.4, it is only the Attorney General that can prosecute all offences in the name of the Republic of Ghana. I think to do justice to this issue, we need to refer ourselves briefly to Article 88.3 and 88.4 of the 1996 Constitution. I think Article 88.3. Also, now, if you have the Constitution, maybe you can read all of us so that we can know it together.
Is it 3 or 4?
So 88.3 and 88.4.
Okay, 3 says the Attorney General shall be responsible for the initiation and conduct of all prosecutions of criminal offences.
Okay.
4 says all offences prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law.
Thank you very much. I think reading the two together throws serious light on this debate that has been ongoing for some time. My personal view has always been that to have a special prosecutor that is truly independent and cannot be more or less influenced, there ought to be the creation of the Constitution. Having said that, if you read Article 88 and 88 together, we need to ask ourselves this question: that if there is a law in Ghana that directs the AG, that grants your authority to anybody, to a certain body, also created by the law, to prosecute specific criminal actions, would that be unconstitutional? Or can the Attorney General say that, or would the Attorney General have the option to withhold such authorization? Well, it forces clearly that where there's a law that grants special procedural powers to anybody, then the Attorney General, in accordance to that law. That's my understanding of 84. So, having regard to the clear terms of the Constitution, I think that because there's an act that specifically gives power to the Office of Special Prosecution to prosecute specific offences, then where the OSP is prosecuting those offences, then we cannot say that the Attorney General has not granted the OSP or that body authority to prosecute those offences. And you see, this is very different from the instances where the Attorney General has granted power to the police to prosecute certain minor offences. In the case of the OSP, there's a clear act of Parliament that has authorized the Attorney General to grant some of his powers, constitutional powers, to a special body, the Office of Special Prosecutor, to prosecute those offences in the name of the Republic of Ghana. And in view of the Constitution and the OSC's Act, my personal view is that the position of the High Court judge is erroneous. Yes, and having said that, I think to bring clarity, there's a question that the Supreme Court may have to answer. And I think there's already a suit before the Supreme Court seeking for an interpretation of Article 8883 and 8834. I think that brings clarity to this matter. Also, because of the guidance of our Constitution, that grants all powers of interpretation to the Supreme Court, especially where an interpretation is being given as to the constitutionality or not of an act of parliament. Then my personal view is that the court do not have that jurisdiction to make such proclamation or give a judgment that in a sense is a proclamation that an act of parliament is inconsistent with the Constitution and that unconstitutional. And I think that's what the High Court takes, and it simply does not have the power to make such proclamations. I think not to sway into personal issues. A number of our friends on TV and radio, a number of people raising issues about the judgment of that judge in particular. So maybe we can also the Judicial Council can look at him and see because there are too many mistakes made by him in particular. But besides that, I think yourself when you read Article 83 and 84, you can make your own judgment. And I think when you make a dispassionate and non-partisan what's called interpretation, you will come to no other conclusion that by a specific reason of Article 84, any judgment or proclamation that speaks to claim that opposition as well have the authority to prosecute specific offenses will be an erroneous one. He may have been right, not in terms of the procedure, but in terms of the substance. If the issues or if the matters that the OSP was prosecuting were not issues particularly and specifically granted under the act that created the OSP and gave the OSP that prosecution powers.
I see. Interesting. Okay, but the law says you shall grant the authority, and I always listen to you lawyers say judges make decisions based on the facts and the law. Now, where you say that an authority should be granted, and a judge looks into whether or not that authority has been granted, and sees that the authority has not been granted, can the judge not make the decision the judge in question did?
And so now your I think I lost you.
Okay. I'm saying that, considering the fact that, and I am quoting most of you I have spoken to many times, that judges make decisions based on facts and also the law. Okay. So the law says that the AG shall grant an authority. A preliminary legal objection is raised, or a legal objection is raised about whether or not that authority has been granted. The judge looks into the case and realizes that even though it is said that that authority should be granted, it has not been granted. Can the judge not make the decision he has made in this case? Hello, La. Hello? Oh, we seem to have lost him on the line. Clearly, he was on the move. We'll try and get him back and conclude the conversation with him on this issue. And if you've been listening to us all morning, we've been on two issues. We've been on the reduction in fuel prices due to the actions of government. And also, we were just talking about the decision of the High Court, a High Court judge, in the case of the Office of Special Prosecutor. Let me remind you, Yellow Ghana, are you a business owner looking for a smarter way to keep an eye on your shop, restaurant, office, or warehouse anytime, anywhere? Well, MTN Business Eye is here for you. Keep your business secure anytime, anywhere with MTN Business Eye, the smart surveillance solution that gives you total visibility and control. It's powered by Wi-Fi, SIM connectivity, cloud storage, and solar energy. So your security never slips, even when the light goes out. Enjoy 24/7 monitoring, real-time alerts, two-way audio, a reliable backup, all at affordable rates. Dial 5060 hash. I think it should be a star somewhere. Star 5060 hash today and keep your business in sight always with MTN Business Eye. MTN, everywhere you go. Now, we do have lawyer back on the line. We lost you there. Just to wrap up, I was asking you a question. Just to wrap up, can you hear me clearly?
Yeah, I can hear you now.
Okay, fantastic. I was saying that, considering the fact that judges make decisions based on facts and law, if a judge has an objection raised about a matter before him, and the objection is about the fact that a law says an authority should be granted for someone in order for the person to come before him, the judge goes into the matter and finds that that authority was never granted. Can the judge not make the decision this judge made?
Preliminary objection act of the judge is one that borders on constitutional interpretation. You understand? And so because this one borders on constitutional interpretation, then the extent that the constitutional as the judge is one that has not been answered. And so then if you move from the judge to stay and then refer the matter to the Supreme Court. Also, if you read the Article 884 very well, in my opinion, the authority, the Attorney General purportedly is granted or not granted, is one that, because of in accordance with the law, you can say that I was not granted. When there's a law, when a law has more or less authorized, more or less created the authority of the AG. So you see, in accordance, so the AG says that even though there's a law that says that I'm granting my authority to a certain body, I can say that I'm not going to grant that. You see, and that's what I'm saying. This is a question that the Supreme Court ought to give clarity to. And to that extent, the High Court judge had to say refer this constitutional question to the Supreme Court. And while the Supreme Court makes its interpretation and proclamation on the said issue, then you can go ahead and then deal with the structural issue, and on the basis of the Supreme Court interpretation, makes his decision in respect of the said preliminary issue.
I see. I guess ultimately you agree with Alhaji Yunus Hussein, who says the judge should have unmasked the objection. That objection was actually asking him to interpret the Constitution. He should have known.
I haven't listened to my learned senior and very good friend. If I'm not surprised, we share a similar view on this question.
Thank you. Thank you for speaking to us.
Yeah, always a pleasure.
Well, what are your views? What do you think? Have I helped your understanding of the matter? Because sometimes the matters can be quite, but it's a simple, straightforward matter. What they are both saying is this, that the judge was supposed to have read the intentions of the people who brought the objection. That the person who brought the objection was actually inviting the judge to interpret the Constitution. So knowing that, the judge should not have gone there at all, should have referred the question to the Supreme Court and not gone into something that is clearly an interpretation of the law. That is the view that they both hold. Well, one more thing, one more business, then we'll take a break and come back.